right, this is case number 21-69091. This is John Lace, L-I-A-C-E versus Arlene the Massa. The matter is before the court on the filing of finished motion for summary disposition. The court they set it on hearing on today's date. Your appearance for the plaintiff in this matter, or plaintiff, your name, state your name if you're on the show. Do I have someone representing the defendant in this matter? Your appearance, please.
Yes, Your Honor, Sean O'Mara on behalf of the defendants.
All right, thank you. Counsel, I do see Mr. Lace. How's that last name pronounced, sir?
Liacci. Morning, Your Honor.
Morning to you, sir. All right, I see that the defendant filed a motion for summary disposition in this matter, also asking for costs and sanctions regarding this matter. Did you get a copy of that motion, Mr. Lice, I believe you said?
Yes, Your Honor.
And I don't see where you submitted a written response to that motion. Did you file anything? Did you put anything in writing regarding the motion, sir?
I haven't, Your Honor.
All right, very well. So, counsel, with regard to your motion in this matter, I know that you know the complaint in this matter sets forth an allegation of damages arising out of renovation of property and claim for some $13,600, and that the defendant stopped paying in regard to the work. Your motion, sir, if you will.
Your Honor, just briefly, it's based on it's a C5 NCA. The plaintiff here is statutorily barred by the occupational code from bringing this action. He's not a licensed builder. In general, any contract for building over $600, you have to be a licensed builder. He cannot maintain his lawsuit in this matter, and that's irrespective of the fact that my clients did pay him approximately $8,000, and that they had to. A lot of work was done wrong, and they had to get other contractors in. But irrespective, this court cannot.
Let me stop there. I know that my sound sometimes can be a little bit crazy. Let me stop you in that part. With regard to the arguments regarding the factual allegations that you are raising to rebut certain factual allegations, you're bringing your motion sounds in a claim that legally the matter has no footing to stand on. And if you'll stick to that, and obviously if some facts to be with that, then I'll hear you on that. But stick to the legal remarks.
Yes, Your Honor, and that's basically it's just clear he's statutorily barred under the occupational code. He's not a residential builder. He cannot maintain this action. I'm sure you've read my brief. The case law is very clear on this fact as well. It's actually a misdemeanor crime to be doing it. It is. So, I will rely on our brief. I'm sure you've reviewed it.
I know that I've never seen it prosecuted, I guess is why.
Nor have I, but it is a crime. It actually is.
There is a criminal provision in the statute on this particular thing, and it sort of happens all the time. But go ahead. I didn't mean to interrupt you. I'm sorry that the sound is kind of off a little bit, and so our exchange can kind of not be synchronized because of the sound. So my apologies. You may continue, sir.
Your Honor, it may be our internet here too. No, I mean, there's not much more than that, Your Honor. The case law is very clear. The Michigan Supreme Court's even stated that, you know, it's all inclusive, that if you're an unlicensed builder, you cannot maintain an action in equity or under a contract to be compensated. So with that, we'll rely on our brief, and we would ask that this matter be dismissed with prejudice.
All right, Mr. Lacey, you understand the nature of the argument that is being raised here, sir, in the motion?
Yes.
Talk to me. Are you a licensed builder? Or are you licensed for the activities that you engage in? Are you under anybody else's license? Go ahead, sir.
No, Your Honor, but I have a few words that I have to explain.
Go ahead, sir.
Okay. Please let's make this clear to Arlene and the court plus TJ that I was referred by TJ's sister's husband, which is my girlfriend's brother, in this matter for $50 an hour.
That's complicated. Sister's brother, boyfriend, husband, but okay, I got you. You were referred by somebody close in this situation.
It's a family member. Yes, Your Honor. To
Gotcha,
do
go ahead.
cosmetic work and to do running and for materials and to find projects and in an orderly, fashionably manner to assist. We cleaned up after every project, what was completed every day on Shrewsbury. Plus, I've had photos and all documentations and hourly and days plus nights of work in this matter for this project, Your Honor. Arlene and we all made a verbal and a written agreement, Your Honor. I asked Arlene to get a homeowner's builder's permit that she did not acquire during this demolition that I was not partaking in. Plus, I not started until one was in place. We agreed I will work on their property for $50 an hour, 8 hours or less per day to get their house up to code for occupancy permit. Based on all my experiences and knowledge of remodeling homes and finding contractors to do this work, my aspect in all that I have done for these people, I was only to do cosmetic work only. I replaced rotted wood throughout the house, replaced front door, installed new windows that were existing throughout the house, up to code. And yes, Your Honor, I'm not a licensed builder. I'm a laborer. I got paid laborer wages to help them out to get this house up to code so they can live in it, which is Arlene's house. Me and TJ definitely had an agreement. He started paying me. Basically started paying me at $1,200 bi-weekly. That's what he said he could afford, which I worked with him. And paid me $2,400 a month. And I have a breakdown of every payment that has been brought to me or paid in forward for this job. And then basically the balance was due. And basically I had to cut ties with them because they would not pay. So, and I did the work. I'm not denying that.
All right. Thank you, sir. So you were kind of reconstructing this place a bit. It sounds like it needed a lot of work. Was it occupied or not occupied?
It was non-occupied.
All right.
It was completely gutted.
And so you put it back together. That's what you were putting it.
Yeah, I found plumbers, I found builders, I found people to help out to get this job completed, like a project manager. And basically that's my knowledge of my kind of work ethic, is to help people out and not get, taken advantage of.
Got it. All right, let me go back to counsel. You get the last word on this, sir.
Your Honor, I believe he's just admitted that he's unlicensed and he was doing work that a residential builder would be doing. He's not allowed to maintain this action. It's that simple. He's statutorily barred.
All right. Thank you, gentlemen. I've listened to the argument on the motion for summary disposition in this matter. That sounds in C5 and C8 alleging that the defendant, that plaintiff cannot maintain the cause of action because of some bar by law, some prohibition. Under the statute set forth with NCL 3392412 deals with residential building and the requirement that where individuals are involved in the practice of residential building and improvement activities, that there be that they have the appropriate license to do so, or that they be barred from maintaining or advancing the cause of action before the court. I've always thought of the statute, and I thought of it as as working some significant disadvantages at times for people who come together and reach what they believe to be a wonderful agreement to get some side help to help them build and reconstruct and so on. Until everything goes wrong, and that is until there's a disagreement. When there is a disagreement, then the law has to be the standard here, and the law does not allow for the enforcement of a contractual agreement for residential building and improvement without there being without the plaintiff being able to show that they have a license to engage in the activity that they're engaged in. The statute is very clear on that issue, and it even addresses the notion of quantum merit recovery, that someone not be unjustly enriched and so on and so forth. And with all of those things in mind, the statutes yet prescribes or prevents an individual from advancing a legal claim on a contract where that contract was entered into and where that contract was executed without the benefit of the petitioner, the plaintiff herein, having the appropriate license to engage in the building activity. So the purpose of such a statute is to prevent fraud, prevent individuals from engaging in a practice that a license to practice in. These kinds of things are particularly relevant when it comes to the practice of law. All of us who are lawyers know it's illegal, improper, and criminal to practice law without a license. That's well established. When it comes to residential building, people hire folks to do improvements all the time. They don't realize that there's a statute that says that you got to be licensed to do it if you're going to use a contract that you have to get paid. So you do the work, and you essentially you do the work, but the only basis for getting paid is that you have a license. You can do the work and work well, but the basis for enforcement of the contract is that you have a license that you're permitted by state law, essentially, to perform the work. There is no evidence that the plaintiff herein is permitted by state law pursuant to a license to engage in the kind of building activity that was involved herein with respect to a gutted residential piece of property. Accordingly, he cannot maintain the action.
Your Honor?
No, don't interrupt me, sir. He cannot maintain this action. Therefore, I will grant the motion for summary disposition. That results in the dismissal of this case. Plaintiff has asked for dismissal with prejudice. The court will not go so far. Maybe there's something else under which the plaintiff can maintain this action. To research that and bring that forward, the court will consider it to the extent that he has an action that he can maintain. Under the case as presented, the motion for summary disposition is granted, and this matter, the effect of that is all right. Good day. Good day.
Yeah, have a great day.
I didn't know you were going to read from that thing like that.
All right, this is case number 12-11-8102. This is Beyond Holdings LLC versus Stephanie Brown. The matter is before the court on a petition on the issuance of a subpoena. Your appearance for the plaintiff in this matter. For the plaintiff, Beyond LLC, if you're here. Do I have Stephanie Brown? Stephanie Brown, if you're present, please say something at this time. No response on this particular matter. Accordingly, the subpoena application will be dismissed. Subpoena is set aside where the plaintiff did not appear on its subpoena. All right, the court is calling case number 21-164-857. This is AHPD 1 versus Michelle Harrison. The matter is before the court on the following Right, that the court pretrial hearing, the court previously allowed discovery in this matter, set it on for a subsequent hearing on today's date. Your appearance for the plaintiff in this matter, please.
Yes, good morning. This is Natasha Dixit on behalf of the plaintiff, JHBD Finance. My PIN number is 82333.
Right, thank you, counsel. Good morning to you. I'm looking for Michelle Harrison on the Zoom. You state your name for the record, please.
Good morning, Michelle Harrison.
All right, thank you, Ms. Harrison. Good morning to you, ma'am. All right, I know that I granted some period that allow for discovery in this matter. I also see that there is a presentation, well, that's a long time ago, a presentation of the recall. So what progress has been made? Counsel, why don't you go ahead and update me on what the status of things are at this point, please?
Yes, Your Honor, certainly. After we speak to Ms. Harrison in the previous pretrial, we did send her, at this point, we have sent her all the account documents that we have. So it was sent to her after our last pretrial. Some additional documentation was mailed to her on January 31st. So maybe she got a chance to review it and, hopefully resolve this, but everything has been sent to her at this point.
All right. So have you all talked at all about the prospect of this matter might be resolved? I see that the complaint in this matter alleges some $3,500, well, approximately $3,600 rising out of a looks like a consumer type credit card or credit line. Is that about the size of what this is about, Madam Counsel?
Yes, Your Honor, that is correct. As of today, the balance is $3,566.58.
All right. Have you all talked about that at all in terms of whether or not you can reach a resolution from your perspective, counsel?
Your Honor, we did not get a chance to talk today. We did speak to Ms. Harrison during the last period, but not today. We did not get a chance to talk. No.
All right, Ms. Harris, you received the information that you requested relative to an accounting regarding this matter. Is that correct, ma'am?
I did, Your Honor.
All right. So is there anything else that you believe that you need at this point, ma'am?
I don't have, so I did review the documents. I don't have statements. I don't have proof of any payments that were made on the initial account, just to be able to verify that whatever the balance that they're giving me, the $3,566.58, is the correct balance that is owed on that account. I do have the bill of sale where they purchased the debt from the original creditor. I do have that, and some of the unfortunately, some of the documents are not specific enough to be able to say that it's even shown that it's owed by myself. But moving past that part, I am willing to speak with her, with counsel today, if there's anything that we can discuss in a breakout room. I'm willing to do that.
Yeah, I think that makes sense. Well, let me ask a couple of predicate questions. And you don't have to answer these questions, Ms. Harrison. Just think about them because they define whether it's relevant to have a discussion. Do you in fact owe a debt? You don't have to answer that. Think about it. Do you in fact owe a debt? Do you have some question number two? Do you have some sense of what you believe that debt might be? And are you prepared, thirdly, to discuss a possibility of resolving the underlying debt? Those are the kind of questions that set the frame for having a discussion. If there is a position that there is no money owed, this is not my debt, and you can't have a discussion because you're at opposite ends of the world. But if there's some thought that that I had something back there, it got lost in the shuffle somewhere, and I know I owe something, I'm not sure the amount, and that makes it worthwhile to go into a breakout room. So I just wanted to raise those things. I'm going to go ahead and set you all in a breakout room, and I will await your return. You're going to receive a notification from me. Madam Counsel, you were in breakout room earlier, number one earlier. You don't have to go back there?
Yes, Your Honor. If I'm assigned to it, I can certainly go back. That was with a different defendant, but if I'm assigned again, I can certainly go back.
Yeah, that was another person. So you go back to that room and I'm sending Ms. Harrison there. Ms. Harrison there.
Thank you, Your Honor.
Thank you.
Yes, thank you.
Are you able to find it? Are you able to do this, Madam Counsel? Madam Counsel?
I'm sorry, Your Honor. Are you speaking to me?
There she is. Thank you.
I'm sorry. I have Global Lending versus Darrell Brown or Darrell Brown.
I see you trying to find a place to jump in, but, you know.
I'm sorry. I thought you were speaking to me.
No,
I'm-
not yet. I'll get to
Okay.
you.
I'm sorry.
Not a problem, man. All right. I'm a little bit behind. It's not you. It's okay. Just one second. All right, let me have case number 15-115-397 Razor Capital versus Melvin Thomas. Matters before the court on objection to writ of garnishment. Your appearance for Razor Capital, please. Do I have Melvin Thomas on the phone? All right, we'll come back to that matter.
Yeah, that's the big five. Yeah,
All right, I see it.
but that's for the third party. Right,
All right, this is case number 20-168-567. This is Ricard Mitchell versus Member Select Insurance and Member Select Insurance Company as the third party defendant. Again, that's 21-68567. The matters before the court on the following of the motion for summary disposition. Your appearance for the plaintiff in this matter, please.
Morning, Your Honor. James Eccleberry, appearing on behalf of Plaintiff Ricard Mitchell, P78222.
All right, thank you, Mr. Eccleberry. Good morning to you, sir. For the defendant in this matter, your appearance at this time.
Good morning, Your Honor. Heather Thatcher on behalf of Defendant Member Select,
All right, your P number, if you will, Ms. Thatcher.
83844, Your Honor.
All right, thank you. All right, is there anyone else appearing on this matter? I know that there was a stipulated order of dismissal for the third party defendant. Any other person present on this Zoom regarding this particular case?
Yes, Your Honor. Brandy Koretich, P61505 on behalf of Nationwide.
All right. Now, so you're, okay, who are you appearing for again, Madam Counsel? Nationwide, I got you,
Yes.
All right. All right.
Good morning.
So, I think Ms. Thatcher, you filed the motion, is that correct, ma'am?
That is correct, Your Honor.
And
We filed a motion as well, Your Honor. I'm not sure if you have that.
I had, Ms. Kirkwood, say that last name for me again.
Koretich.
Earlich. All right. And which motion did you file? What did you file?
We filed a motion for summary disposition based on 3173A4.
Your Honor, Nationwide's motion was filed on February 17th, 6 days before this morning's hearing, which is in violation of the court's order that at least 7 days notice be given for the filing of any motion. We did file a response to that motion, I believe on Friday. But given the court's closure on Monday for President's Day, I don't know if the court has received that response yet.
Yeah, that's what I'm looking for. I know that I have the, hold on one second. Just let me get. I do have Nationwide's motion. Just one moment. Of course, I have Member Select's motion. That's been here for quite a while. Second. I have plaintiff's response to the Nationwide's motion as well. Just one moment to see if we have a response. No, I do not have a response on Nationwide's motion. So, and I see that the motion is timestamped here at court on the 18th of February. So it looks like all of this is very recent. When I reviewed this last week, I did not see the motion for the motion on behalf of Nationwide. So I really haven't had a chance to look at that one. And Mr. Aguilera, I don't think that your response is made to file on that one either. So it would be probably prudent on my part to set that for another time so that the court can take a look at it. So let's delve into just let me see what the issues are with regard to the motion filed by Member Select for summary disposition. I've looked at it and the answer also. So you may proceed at this time, Madam Counsel, regarding that particular motion.
Thank you, Your Honor. As the court is aware, the date of loss in this case was November 26, 2019. Plaintiff Ricari Mitchell was a pedestrian on that date when she was struck by a vehicle crossing the street in Detroit. She was listed as a rated driver on a policy issued by Member Select to named insured Bonnie Fluellen. She was the rated driver of a 2015 Ford Focus. After investigation of plaintiff's claim, and it must be noted for the court's record that we didn't find out about plaintiff's claim until nearly a year later when it was reported to us by her attorney. But after receipt of her claim, we investigated, of course, as we do with all claims, and we learned that not only was she not a named insured under our policy, she was not the spouse of a named insured, nor was she a resident relative of the named insured. And we informed her after the fact that we were not approving her claim. And as you know, MCL 531.15 controls the order of priority in cases such as this. And the statutory language is unambiguous, and it provides that a person, except for as provided in section 3114, subsection 1, a person who suffers accidental bodily injury while not an occupant of the motor vehicle shall claim personal protection benefits from the assigned claims plan. And through our investigation, we learned that the assigned claims plan had assigned this claim to Nationwide. And section 3114.1 reads in pertinent part, except as provided in other subsections which don't apply, personal protection insurance policy as described applies to accidental bodily injury to a person named in the policy, meaning named insured Bonnie Fluellen, the person's spouse, or a resident relative of either. And in Nationwide's response, they pointed to policy language, which was in section 23, which defined you, your, or a named insured as any person or organization named on the declaration certificate as number or letter A, rather, the principal named insured, in this case, again, Bonnie Fluellen, or an assigned driver, only if the assigned driver is a titled owner of the insured car to which he or she is assigned. Plaintiff admitted in her application for benefits to the assigned claims plan, which I will note was filled out 7 days after the motor vehicle accident, that she did not own any vehicles and she did not have auto insurance. So she herself admitted 7 days after this accident that she was not eligible for benefits through Member Select. And it's plaintiff's burden to prove that not only was she injured as a result of this accident, but that she's entitled to PIP benefits through a policy issued by Member Select. And none of the facts so far that I've mentioned have been disputed by any affidavits, any documentary evidence which would refute them. So considering all of those things, we respectfully request that the court grant our motion with prejudice and dismiss Member Select from this lawsuit.
All right, Mr. Eccleberry, this priorities issue, go ahead, sir, if you will.
Thank you, Your Honor. Yes, the issue here, Your Honor, is that defendant's motion misrepresents the policy language and the language contained within the declaration page itself. If you look at plaintiff's response and attached as Exhibit 1, you will note that within the declaration page, there is no distinction made between Bonnie Fluellen or Ricari Mitchell. They're both identified as insureds under the policy. And that makes sense as elaborated on by a third-party defendant Nationwide. The definitions within the policy cover Ricari Mitchell's PIP claim in addition to Bonnie Fluellen. Now, the court might ask why Ms. Mitchell submitted her claim to the MAIPF if she had this insurance through AAA. And I think that it's important for the court to keep in mind the timing of this accident. This accident happened at the time that the No Fault Act was reformed, including reformation to the priority changes. So essentially, Member Select is attempting to penalize her for being overly cautious as opposed to, taking a chance that she might have interpreted the change in the statute wrong, which is particularly relevant given the subsequent litigation between the DIFS Association and Ms. Anita Fox, the DIFS manager, and the MAIPF itself, which resolved the question of when the priority statute took effect and what to do with claims that fell into the period of time post no fault reform, but before the resolution of that action up in the Court of Appeals. Ultimately, the policy itself extends coverage, and that's particularly relevant because the No Fault Act establishes the bare minimum for auto insurance coverage. It is for the parties and carriers to contract, and you can contract for greater than minimum coverage, which is exactly the case here. Member Select's policy extends benefits to Ms. Mitchell, and she should be entitled to those benefits. At the very worst, the policy language itself is ambiguous, and that policy language should be construed negatively against the drafter, which of course would be Member Select. The motion should be denied, and in either event,
Let me stop you for just, Mr. Eccleberry, let me stop you. Mr. Johnson, your sound keeps interfering with his hearing, and every time I put you on mute, you take yourself off mute. If I put you on mute again and you come off mute, I'm going to dismiss you out of the hearing. So that's what you have to do. Wait until I come to you. Thank you, sir. You may continue at this time, Mr. Eccleberry.
sorry, Your Honor, where did I lose you?
I'm not sure, quite frankly, but pick up somewhere and just keep going. I was distracted a little bit by something that kept happening. Go ahead, sir.
Okay, so I guess I'm going to circle back for a moment and point out to the court that the motion itself was actually filed under two provisions within MCR 2.116, C8 and C10. C8, failure to state a claim. My client's claim for PIP benefits is clearly a cause of action under Michigan law, so there's no basis for the motion under C8. With regard to C10, that delves into the contractual language and whether the policy, Member Select's policy itself, extends benefits to Ms. Mitchell or exceeds the minimum coverage provided under the No Fault Act. Case law says that there is absolutely nothing wrong with going beyond the minimum coverage afforded by the No Fault Act, which Member Select's policy does and covers Ms. Mitchell. On top of that, there is also case law that very clearly holds that the assertion of a priority dispute is not a defense to a no-fault action. The appropriate course of action and what the insurance carriers should do is pay PIP claims and then subrogate amongst themselves if they believe there is a higher priority insurance carrier involved. So not only do you have a defense that's not a defense pursuant to the case law, but it is not consistent with the policy itself. And for those reasons, the motion should be denied.
So, Madam Counsel, where the claimant is named under Member Select's policy, what impact, if any, does that have on the priorities argument that you've raised?
Well, just to respond to what a plaintiff's counsel has stated, Your Honor, we didn't misrepresent anything in the policy, nor did we misrepresent anything in the statutory language. Ms. Mitchell is noted on the policy only as a rated driver. Whenever someone submits to any insurer for coverage, they have to declare who the regular driver of insured vehicles are. There's no difference in this circumstance whatsoever. She is a rated driver, not a named insured, not a resident relative, not the spouse of a named insured. Simply, she just does not qualify under Member Select's policy. Not only that, in reference to the policy itself, the policy clearly states in Part 2 that we agree to pay only as set forth in the code, meaning the No Fault Act. We subjugate our policy to the code, and we've won several MSDs on this order of priority issue on the 3114, 3115 basis. Aside from that, I'll rest on the arguments, in my brief and the motion itself.
Your Honor, if I may.
Yes, sir.
Your Honor, Plaintiff's Exhibit 1, page 3. If the court would turn to that page, you will, in looking at that page, you will note that within each policy section, there is no distinction made between Bonnie Fluellen and Ricari Mitchell. There's nothing to distinguish one as a named insured and the other as an assigned driver. They're both identified as drivers in the Your Policy Summary section. And then down further on the bottom half of the page in the rating information, it identifies both Ms. Fluellen under driver types, which I've highlighted for the court, as being assigned. It also has a AAA insured since, and it gives the dates that each became a AAA insured. These are AAA's own documents saying that Ms. Mitchell is an insured.
I have to disagree, Your Honor.
Mr. Thatcher, I'll come back to you. Mr. Eccleberry, what are the argument that is raised by Madam Counsel regarding the subjugation of their claims and provisions under their policy to the no fault statute, if you will, and the assigned claims mechanism, sir?
Your Honor, I think that Nationwide's response to this motion lays out the policy language and cites it word for word. And you can see within the policy language that although they have what I would call a savings clause within the policy, the definitions speak for themselves, and the definitions include or encompass Ms. Mitchell. So to say on one hand that, oh, of course, we subjugate ourselves to the policy, while that's true in the sense that the policy establishes the bare minimum, it does not limit the policy from extending above the bare minimum. To give you a different example, it would be similar to a claim for uninsured motorist coverage. Uninsured motorist coverage is found nowhere within the No Fault Act, but it's found commonly within auto insurance policies. And that's because it is a type of coverage that extends beyond the act itself. Here, it's the same principle, where you've got a contract, and of particular note, the contract was drafted based on the pre-reform version of 3114, which would have included Ms. Mitchell. Well, it includes Ms. Mitchell either way because it's her policy, so that doesn't change. It's still the provision you look to is MCL 531.14, subsection 1.
If I could just add to that, Your Honor.
Yeah, I'm gonna come to you. I'm gonna come to you in just a moment, Madam Counsel. Let me go back to the statute. As to the characterization of the various parties named under the policy, it seems that that's a part of the dispute as to what that characterization means, whether or not they're named insured or whether they're simply noted as drivers. And Mr. Eckleberry drilled down on that a little bit. Your response, I know you had something that you were saying. Go right ahead, Madam Counsel.
Yeah, just to add on to
I'm at Ms. Thatcher now. I'm at Ms. Thatcher. I'm at Ms. Thatcher, then I'm coming to you.
Okay.
Ms. Thatcher, please.
Yes, Your Honor. When the policy speaks about Ms. Mitchell in the various places that it does, it speaks with her or about her only as a rated driver. When it lists the rating factors at the end of the documents, that's in an effort to determine the cost of coverage, rating her as a driver. And the policy is very clear. Any policy that's issued by Member Select, the named insured is listed at the very top of the document. And it says very clearly, Bonnie Fluellen and no one else. Not only that, I mean, we obviously fundamentally disagree, but we're not talking about coverage here. We're talking about the PIP coverage. We're talking about order of priority. The statute is very clear. Our policy is very clear. It does not extend PIP benefits to Ms. Mitchell. And not only that, Ms. Mitchell represented herself that she did not have insurance when she signed the application for benefits 7 days after this motor vehicle accident. And even she admitted to not being the title holder, which Nationwide points to in their response that would make her eligible for coverage. She admitted that she was not the title holder. She did not own any vehicles 7 days after the accident.
Ms. Madam Counsel at the top there.
yes. I would just add Ms. Mitchell actually signed an amended application for benefits where she does state that she is a co-owner of this 2015 Ford Escort that is listed in the Member Select policy. And then just going back to the definitions under the Member Select policy, it expands the definition of a named insured and would include Ms. Mitchell as long as she is the titled owner of the vehicle, which she testified she thought she was. So based on the evidence that's before the court today, there's insufficient documentary admissible evidence to grant Member Select's motion, because under the policy definitions that I laid out in our response, Ms. Mitchell would be considered a named insured under that policy if she is on the title for that 2015 Escort that she is listed as the assigned driver of.
Your Honor, if I may, excuse me, again, this is plaintiff's burden to prove. A very simple remedy for all of this would be for plaintiff to include it in her response, a title, a copy of the title showing her as the title owner, which would, render her eligible for coverage. She has not done that. There's been no proof that plaintiff is eligible for coverage under our policy or under the statute.
Your Honor, it only becomes plaintiff's burden if defendant presents a prima facie case for summary disposition. Here, the record that you've been given does not make a prima facie case for summary disposition. The testimony is clear. The AAA's own policy, how they identify Ms. Mitchell, is clear. This motion should be denied.
I agree that the policy is clear, but the motion should be granted, Your Honor.
Well spoken. Well spoken there in the end. All right, the court has listened to the argument on the motion for summary disposition. At best, it's not the issues are not right before the court at this time. There are potentially, it seems, significant factual disputes as to what the position of the claimant is under the policy. I know under the Exhibit 1 attached to plaintiff's response to the motion, it sets forth Bonnie Fluellen as the principal named insured. as well as address. And it says the principal named insured. What does that mean in relationship to other people that are noted in the policy? And then also there is the issue that has been raised that that the claimant here has indicated at one time shortly after the accident that she did not have a titled interest in the subject motor vehicle or motor vehicles on the policy. And subsequent to that time, she's offered something that is different to that. There are factual disputes that yet remain open at this time, and it would be imprudent at this time for the court to grant the motion for summary disposition in this regard. For that reason, the court will deny the motion for summary disposition, finding that there are substantial factual disputes, and moreover that that there may very well be the right of defendant strike that claimant Mitchell to claim under the member select policy. That issue has not been dismissed by the factual scenarios that exist in this case at this time. And for that reason, again, the motion for summary disposition will be denied.
Thank you, Your Honor.
What is the issue with regard to Nationwide as to its motion for summary disposition? I know I said it would put it off. Madam Counsel, tell me a little bit about that.
Yes, Your Honor. So under 3173A subsection 4 of the Michigan No Fault Act, our argument is that she has misrepresented facts on the application for benefits that later her medical records disputed. So she said in her application for benefits that she did not have any prior knee pain or any complaints with regard to her knee. She again testified to that at her deposition, but there were medical records that were received showing that she did complain of acute knee pain just 9 months before the accident and received treatment for a few months for that knee pain. So our argument is that she misrepresented facts and therefore she's ineligible for benefits under the assigned claim plan.
Your Honor, the application actually asks about prior injury to the same area of the body that was injured in advance of the accident or at the time of the accident. The medical record referred to 9 months before the accident is a generic or general complaint of knee pain. There was no diagnosis or report of a quote unquote injury, nor was the diagnosis after that emergency room visit of any injury or any identifiable condition. It was simply a complaint of pain. And what defendant Nationwide's motion does is it attempts to substitute different terms or conflict rate discrete terms, i.e. injury versus pain.
Actually, Your Honor, the application for benefits asks for any medical conditions, which she did not identify. The only medical condition she identified was arthritis, which she testified was juvenile arthritis, and she hasn't treated for any of that in 5 years before the accident. So the failure to disclose this knee pain when she is having knee problems that she's associating with injuries from this car accident and for which she has received a referral for surgery is a material misrepresentation that should preclude her from getting benefits under the assigned claim plan.
Your Honor, the application speaks for itself. It asks about injuries, but be that as it may, it is defendant MAIPF or Nationwide on behalf of the assigned claims plan's burden to prove each element of fraud has been met, including reliance on the alleged material misrepresentation. So plaintiff's dispute, I know you don't have the benefit of my response, but first is that no misrepresentation was made. Second, even if an innocent misrepresentation was made, it's not material because we made available all of the medical records anyway. And third, Nationwide hasn't paid anything, so how can they have relied upon something when they didn't extend benefits?
Under 3173, the No Fault Act, that provision, a fraudulent intent is not required and neither is reliance on it. All we have to show is that she made the misrepresentation and that it was material to the claim.
That's, I disagree with that, Your Honor, and I briefed on that issue. You still need to show fraud.
All right. All right, I've listened to the argument on this motion, and obviously the statute that precludes claims first party benefits where there is some covering up, if you will, of underlying conditions or previous injuries as a way of course recovering benefits where benefits should in fact not be allowed. The sense of the statute certainly addresses the issue where there is some attempt to cover up the underlying causes or injuries or conditions such that benefits would be paid under circumstances where they should not be paid. That's the sense of the statute. I mean, it's while it does, the statute does not look to a strict fraud analysis. It would be nonsensical for a statute to say that where a person is that even a mistaken representation would somehow preclude it from the recovery of benefits. Well, in this situation, it seems to me that no benefits were paid, number one. Number two, that in the process of discovering and investigation, that all of the information that was necessary was made available, and that there has been no compounding of any issue as it relates to covering up, if you will, any condition that would preclude coverage under the statute. I just don't think, based upon what I've heard here, that this is enough to rise to the level that there was some kind of intentional, if you will, and or material misrepresentation for the purpose of securing benefits. I don't see that connection here, and maybe a more significant factual development would have to be made in order to be a predicate for the underlying motion. For that reason, at this time, the motion for summary disposition will be denied as presented to the court at this time. That's my order. With regard to both motions, and somebody submitted an order under respective motions at this time. Again, it seems to me that in regard to both of the motions that were brought before the court, that there may be further factual developments that might impact the way that a court might look at those issues. It just seems to me that the motions are not altogether right for purposes of being able to, for this court to give any consideration that will result in the granting of the respective motions for summary disposition. I join them together now in some way, simply because it seems to me that the predicate that would satisfy the advancing of the motion under the summary disposition, the fair summary disposition rules, that there's not sufficient predicate under either one of the motions. For that reason, among others that I've said on this record, the motions are respectively denied.
Is that without prejudice then, Your Honor? Do you believe there's more factual development?
That is why I stated it the way that I've stated it. I mean, it's clearly in both instances without prejudice. The priority issue could come back up. I might have to take another look at that if there's something developed beyond what was presented here today. And certainly, if there is some material misrepresentation that is somehow tethered to the application for benefits that seeks to somehow acquire benefits where benefits should not be permitted, then certainly that becomes a moving issue as to how the court has to take a look at this. I don't see those developments in either motion at this time. All right, thank you. I know that took a little while. Thank you. Submit your order to me, and I'll sign off on the order denying summary disposition.
Your Honor, do we have a return date?
Thank you. You see me rushing to the next case, and The moment I saw you light up there, I said, she's getting ready to ask me about the next date. So for sure, let's get a date on this, about 30 days or so out. We'll be on
April 6th.
April 6th, 10 o'clock a.m., April 6th, 10 o'clock a.m. And again, I know that that's relatively close out, but if you have a motion or something that you wish the court to hear at that time, I am treating it as a final pretrial conference. If you've got something you want to file, make sure that you give the other side at least 7 days prior to the hearing to respond, and I'll hear it on that date, 4/7 at 10 o'clock a.m.
4/7 or 4/6? I'm sorry.
Let me talk to my clerk.
Huh.
You said 4/6?
4/6, yeah.
It's 4/6.
Okay, thank you, Your Honor.
Thank you.
Thank you, Your
Have a
Honor.
good day.
6, I said 7, it's 6, 4/6, 10 o'clock a.m.
Yes, thank you so much.
Thank you.
All right, stay tuned for it. Thank you, Ms. Diddick. Welcome back. And Ms. Harrison, welcome back. On the suffix 4857, Madam Counsel, you previously made your appearance, and I see you there, Ms. Harrison. Counsel, update me if you will.
Yes, thank you, Your Honor. I did speak to Ms. Harrison, and we did discuss settlement. Basically, she provided a settlement offer that I told her I'll have to submit to my client for review based on that amount. But I do have her contact information. I'll provide her an update once I receive one. So this is where it stands, Your Honor.
All right, Ms. Harrison. So we all know where it stands. I'm going to go ahead. I'm thinking to put it out 30 days and then review this, or do you want to come back sooner than that, Counsel?
Oh, yeah, I think minimum of 30 days would be best, yes.
All right, so Ms. Harrison, I'm going to set it out about 30 days. Give me a date, Madam Clerk.
Thanks for giving me, I think 30th.
3:30, 9:45 a.m., 3:30 and 9:45 a.m.
Okay.
Oh, yeah, so that is March 30th, 9:45 a.m.
That's correct. And Ms.
Thank you.
Harrison, you'll get something in the mail. Ms. Harrison, you have that date, is that correct?
That's correct, yes.
All right, I wish you well. See you next time.
Thank you.
And adjudicated next year.
Will I be, is it okay to speak now, Your Honor?
Of course not. You can speak when your case is called. All right. The court now calls case number 21-159-713. This is Ford Motor Credit Company versus Bria Brown. The matter is before the court on the application for entry of default judgment. The default was previously entered where the defendant did not answer or appear regarding this matter. Your appearance, counsel, at this time.
Good morning, Your Honor. Deborah Winslow, P63179 on behalf of the plaintiff.
Good morning to you, Ms. Winslow. Do I have on this record Bria Brown? Bria Brown, if you're on this record, please say something at this time. Record should reflect the matter was set on for 10 o'clock a.m. The defendant has not previously appeared and did not appear on notice regarding this hearing. Accordingly, the court will now enter the judgment by default on the terms as prayed. The judgment will enter for $8,827.44. It is so ordered. I've signed that order, Madam Counsel, that will be sent out today. Right?
Thank you, Your Honor.
Thank you so much for your patience.
Have a nice day. Thank you.
The court now calls case number 21-159-348 Jefferson Capital Systems LLC versus Yolanda Smith. The matter is before the court regarding application for entry of a judgment by default. Defendant did not previously answer and a default has been entered. This is a request for entry of the judgment itself. Your appearance for the plaintiff in this matter.
Good morning, Your Honor. Naljat Francis, P72322, on behalf of Plaintiff's Attorney of Record.
Thank you, Ms. Francis, and good morning to you, ma'am. I'm looking now for Yolanda Smith. Ms. Smith, if you're on the Zoom, please say something at this time, ma'am. Yolanda Smith. It looks like the defendant has not appeared for this hearing. She did not appear for any of the activity in the underlying case. Accordingly, now the court will go ahead and enter the judgment by default. The judgment on entry will be $5,014.02. The order is signed at this time. Thank you, Ms. Francis.
Thank you, Your Honor.
The court calls case number 21-59169. This is First Financial Bank versus Daniel LaGreco regarding an application for entry of judgment by default. The court did notice this matter for hearing at 9:45 actually, and it's set for entry of judgment. Your appearance at this time for the plaintiff. You're on mute, if you will.
Well, I'm sorry, Your Honor. Yes, good morning, Your Honor. This is Natasha Dixit on behalf of the plaintiff, First Financial Bank USA. My P number is 82333.
All right, thank you, counsel, and good morning to you again. I noticed that that this is an application for entry of judgment. Do I have Daniel on this Zoom? Say something if you're here, sir.
I'm here, sir, Your Honor.
All right, good morning to you, Mr. DeGreco. Mr. DeGreco, this hearing is an application for a judgment to be entered in the amount of $8,452.04. That's because you didn't file any answer or respond to this case, and a default's been entered against you already. Do you understand that, sir?
I do understand that. I had a meeting in the breakout room earlier to get a settlement.
All right. Did you talk to someone already?
Yes.
Two of you? Oh.
Yes, Your Honor, we did.
Okay, tell me what's going on.
Yes, Your Honor, I'll provide an update. So I did speak to Mr. LaGreco, and we did come to a settlement agreement. And if I may, I'll just put that on the record, if I may. So he'll be paying, so the current balance is $8,220.73. We reached a settlement of that he would pay $5,760 by March 25th of 2022.
And that amount will resolve the entire claim?
Yes, that is correct, Your Honor. So since he hasn't filed an answer, we'll, after the funds have cleared, after the payment has been made, we'll be sending a dismissal to the court.
All right. So I got $5,760 to be paid by what date?
March 25th of 2022. So that's March 25th of 2022.
Got you. And the judgment would enter for $8,220.72.
Yes, Your Honor. So that's 73 cents, $8,220.73.
I missed it by a penny. Right. And so what's going to happen is once that payment is made, $5,760, and that will satisfy this. And you indicated, Madam Counsel, that you would stipulate to setting the judgment aside. Is that what it is?
Yes, Your Honor, but since he hasn't filed an answer, I don't think we'll do a stipulation. It's just that once the money has been received, all the funds have cleared, the plaintiff will just send a dismissal because he hasn't filed an answer. So if that's okay, we'll just send a dismissal as opposed to a stipulation, if that's okay.
Got it. So the question that I was raising really was about entering the judgment now. Do you want me to enter the judgment now, or am I just waiting on the settlement funds, or which way was it agreed upon?
Oh, I think so, Your Honor. I think for now we won't enter the judgment since we did reach a settlement. So as opposed to going to the judgment, of course, if we don't receive the money for whatever reason, but we are hopeful we can resolve this. And
all right, Mr. LaGreco, is this the agreement that you entered into, sir?
Yes, sir.
All right. And so, yeah, you understand, of course, if you pay the $5,760 by March 25th, 2022, that this case would be dismissed. You understand that?
Yes, Your Honor, I understand that. I will have that paid by March, by the end of March.
And here's the bad part. If for some reason that you don't pay it by the 25th, then I will enter a judgment for $8,220.73. And that will be a judgment against you that you'd have to deal with after the 25th of March of 2022. You understand that, sir?
Yes, Your Honor.
All right, so what I'm going to do is I'm going to go ahead and set a control date. That's going to be March 31st, 2021, 2022, I'm sorry, March.
There's no more, you say March 31st?
30th.
Or 31st? 31st.
March 31st, this is just a control date. It gives the two of you an opportunity to come back. If not, what will happen is an order is going to be submitted dismissing the case. But if something goes wrong, you got March 31st, 2022 at 9:45 to come back into the Zoom so the court can address any issues that might be involved. All right, good day to the two of you.
Thank you.
Thank you, Your Honor. Just to clarify, so you said March 31st was at 9:45 a.m.?
That's correct, counsel.
Okay, thank you.
Are you all set? I
Thank
noted the 5, and we'll see you on the 31st. Hopefully, I don't have to see you. I get an order to discuss it, but good day to you.
We will. Thank you.
Thank you.
All right, this is case number 21-158623. This is Cap Portfolio LP versus Thaddeus Watkins. The matters before the court on an application for entry of judgment by default. The default of the defendant has already been entered. This is a request for entry of a judgment on that default. Your appearance for Cap Portfolio, please.
Good morning, Judge. Christopher Asphalt, 53129 for the plaintiff.
Thank you, Mr. Aswell. Good morning to you, sir. Let me see if I have on the Zoom Watkins, Thaddeus Watkins. Mr. Watkins, if you're on the Zoom, please say something at this time. All right, the record should reflect that the court did send out notices to Watkins on Sheridan Street, address provided previously to the court. The court will now sign the judgment in this matter where the defendant has not appeared. The judgment will enter for $4,189.73. And I've signed an order to that effect at this time where the defendant did not appear and where the defendant has not previously appeared regarding this matter. So ordered.
Thank you, Judge.
Thank you, counsel. The court now calls case number 21-161-300 Global Lending Services versus Daryl Brown Jr. The matter is before the court on an application for entry of judgment by default. Your appearance for Global Lending Services, please.
Good morning, Your Honor. Attorney Ashley Nonis, P77029 on behalf of plaintiff.
All right, thank you, Ms. Norris. Thank you for your patience this morning, ma'am. I'm looking for Mr. Brown, Daryl Brown. Brown, if you're on the Zoom, sir, please say something at this time. The matter is before the court on an application for entry of judgment by default. The defendant did not respond in the underlying to the underlying complaint and has not appeared, it seems, on this date. Accordingly, the court will now enter the judgment by default on the terms as prayed. The judgment will enter for $9,802.52. It is so ordered at this time. Thank you, counsel.
Thank you, Your Honor. Do you have an order or do you need me to submit one?
No, I just signed the order that was already submitted.
Oh, great. Thank you so much. Have a great day.
Likewise to you. All right, the court is calling for Case number 21-154-395. This is LBNB funding versus Tanisha Head. Matters before the court on an application for entry of default judgment. Your appearance for LBNB funding.
Good morning, Your Honor. Sam Cermak on behalf of LVNB Funding, P85146.
All right, thank you, counsel. Thank you for your patience regarding this matter. I see it's set for 10:30 a.m. That's been a little while ago. Let me see if I have Ms. Head on the Zoom. Tanisha Head, if you're on the Zoom, please say something at this time, ma'am. All right, it looks like Ms. Head has not appeared for this hearing. We did send a notice to her inviting her to do so on Navarro Street, Detroit. She did not file an answer to the complaint or otherwise defend. Accordingly, now the judgment will be entered by default on terms as prayed. That is, the judgment will enter for $6,688.02. The court has a judgment on signing order at this time. Thank you, counsel.
Thank you, Your Honor.
All right, Razor Capital versus Melvin Thomas. Melvin Thomas.
Yes, sir.
All right. I called this earlier. This is objections to a writ of garnishment regarding the Michigan Department of Treasury. Do I have Razor Capital on the Zoom? Razor Capital. All right. All right. So, Mr. Thomas, this case is brought before the court as a result of a judgment that was entered back in 2016. The judgment amount is, at the time that it was entered, $3,197.29. That judgment has not been satisfied, and that's why you got the writ of garnishment against the Department of Treasury for the state of Michigan. All right, so what's going on, sir?
My cousin, her name is Tracy C. Thomas. She's been using my social security number for years. Thank you, son. She's been using my social security number for years, doing all kinds of, like, she get DTE, she's got credit cards in my name. Can you please stop doing that? Like, don't make no noise, please. Sorry about that. She gets everything in my name, and she uses my social security number. And Stinger has been like, the whole time, I'm kind of young at this, and like, now that I know, the whole time that I'm thinking that I'm paying money, building my credit, I'm paying off a debt that she's created in my name. I've been paying this debt off since I was like 16. Another thing, like, that every year they keep garnishing my money. Any kind of lump sum that I go through with a lawsuit, they take majority of that. It's just a lot of fraud going on with my cousin. I don't understand how is they able to keep taking money that I'm earning for me and my kids, and then they keep putting on all of the paperwork. It say plaintiff attorney Stinger and Steiner versus defendant Tracy C. Thomas, but everything is under my social security number. Like, how is she able? Like, why they're not going after her? Why is it like I keep having to pay off a debt that she's doing? And another thing, I know I'm talking fast. It's just like, this is the first, I haven't talked to anybody that can handle this situation besides you. I got her telephone number. I got her address, everything. Like, they need to be going after her, because the money that they've been taking from me, I want all of my money back. And I want to press charges on her too. Like, I don't know if I'm, like, they done took everything, Your Honor. I wrote you a note as well.
Yeah, I've read your, I've read the note that you sent to me, as well as other documents that you presented. Here's the issue. You can't attack the underlying judgment in by objecting to the writ of garnishment. The writ of garnishment or garnishment is what's called post judgment. They are things that happen after a judgment is entered, and you can't attack the judgment itself by attacking post judgment stuff. So what's happening is that you get a garnishment and then you file objection to the garnishment. If you want to challenge the underlying judgment, you have to file something and provide an affidavit and other documents to ask that the judgment be set aside. You have a judgment that was entered against you back in 2016. When that judgment was entered, it was entered by default, meaning that you did not respond to the complaint that was filed against you. And when you don't respond to the complaint, then after 21 days, a default is entered, and then shortly after that, a judgment gets entered. So back in August of 2015, you were served with a summons and complaint. And it says here that it was served personally on you back in 2015. You did respond to that, and then in November, that was August that you got the service. In November, the default was entered.
Is it, not to cut you off, is it my signature, Your Honor? This lady keeps, she said, is it?
It don't have to be your signature. See what you're dealing with. Okay, you want to talk? If you want to talk, I'm gonna let you talk. Don't talk.
Your Honor, she keep changing the address. She keep on switching it up. Like she'll send it and then change the phone number and then like say that I agreed to something. She keep paying on certain things. I never lived in Romulus. The addresses that they're contacting, they mailing out. She's smart. She a scammer, and it make it seem like it's me. Go ahead.
Everything you say could very well be true. Your question is how do you do anything about it? Well, the thing that you got to do, if you want to do anything about it, you need to file a police report. You need to get all of that flagged on your license, et cetera, so that you can have it noted that there is a person that is doing a fraud against you. You need to file a police report, have them to investigate it, and have them to make some determination as to who it is and what it is that they are frauding you out of. And if this is a person that you know that's defrauding you, you got to take that to the police so that they can work on that. Now, the problem that you have with this case is that a lawsuit was filed against you back in 2015. When that lawsuit was filed against you, they served you with the notification that you were being sued. You didn't respond to that. And when you didn't respond to that, you didn't respond to the lawsuit. I'm not talking about whether or not you dealt with going to the company that was claiming the debt. You didn't respond to the lawsuit. When you didn't respond to the lawsuit, a judgment was entered against you. That's what you're dealing with now. You're dealing with a judgment against you. And because that judgment is against you, every time or anything that the plaintiff finds that they could collect on, they can file and use this judgment to intercept your bank account, intercept your employment, your wages. They have a judgment against you. So your goal has to be to find a way that maybe you can get that set aside. So you might want to file a motion. But when you file a motion, that motion is going to have to be based upon something. You need police reports or something, or police investigation or something showing that this debt with Razor Capital was fraudulent. If you can show that, you may be able to get the judgment set aside. But again, what you're trying to do now is go back 7 years. This judgment has been entered since 2015. You're trying to go back 7 years. So you need to file a police report. You need to get them to investigate it. You need them to be able to pin this on somebody other than you. Otherwise, this judgment is going to continue to stay in place. And as long as it's in place, the plaintiff has the right to use any collection method that's permitted by law. Garnish your wages, garnish your state income tax, garnish lawsuit proceeds, garnish, they can't garnish federal wages or federal income taxes, but they certainly can do it with state income taxes. That's a part of what this is about. If you win a Michigan lottery, they can garnish that, anything that's at the state level. And that's what this objection, that's what this garnishment is about. They're seeking that if you are receiving a tax return, that they want to be able to intercept that because they have a judgment. Under law, they're able to do that. The only way you can do anything about that is you got to come against the underlying issue here, and that's the judgment. And when you attack that judgment, you got to file something that's in the nature of a motion to set aside the judgment. You got a motion to set aside the judgment. Or you can call it a petition or a motion, whatever you want to call it. There are forms available on the second floor of the court building. And also those forms are available. You can Google for court forms.
Now I'm just gonna come straight back up there and file those motions, and I don't mean to cut you off, but I don't understand, Jan. I'm definitely, you're open today. I'm actually, as soon as we get off the phone, I'm on my way back down there. But I don't want to do this. You said the paper. How is it that her name is under my social security number? Why it says versus Tracy C. Thomas, but it's my social security number, but it's not me. And then they keep taking my income tax money.
Well, I can tell you how they're taking your income tax money. They're taking your income tax money because there is a judgment that's against you. The judgment is not against Tracy Thomas. The judgment is against you. That's why they're intercepting your income. Now, why and how she uses your social security number, I can't answer that. I don't know that part. I have no idea. I know that if you believe that somebody is defrauding you and is doing identity theft, you need to report that to the police. You need to have that investigated. And until you get that investigated, get that resolved, you're going to have a hard time getting anything done regarding your case that you have before the court. Because
they gave me 28. They gave me 28 days to put a hold on my funds until I contact and have a court date. The IRS, because you have the paper. I don't have to keep doing that.
Not the IRS. The IRS is not involved in this because they can't garnish your wages with the IRS. You mean the Michigan Department of Treasury?
Yeah, Treasury, not the IRS. Treasury, sorry about that. Treasury, they put a hold on the funds until I take care and I come to court with the attorneys and everything. It says 28 days from the payee or whatever it is. I sent you a copy of it. So what is, because I don't want to have to keep paying for something that she's messing up. So what, I got the police report, file a motion. What else I need to do?
Well, that's all you can do at this point. As it relates to the funds that they're garnishing, they're going to be able to take those funds. But if you can show in the future that this judgment should be set aside, then any money that's been taken from you has to be refunded to you. Not only regarding this income tax, but any other money that was taken. If you get that judgment set aside, the plaintiff has to return all the money to you that they've ever collected. But that's the hill that you got to climb. You got to find a way to get that judgment set aside. And one of the ways that you could possibly do that is to prove that somebody else stole your identity and that is their debt, and that you had it investigated, and that there is a determination by the police that this person has defrauded you. You may be able to get it set aside under those circumstances. Without that, the judgment is going to remain in place.
Okay, so basically what you're saying is get on your business, Melvin. Contact.
Yeah, I mean, that's the only thing that you can do. I have to deny the objections right now because the judgment's in place. Your job is to see if you get the judgment out of place. You got to file a motion to try and do that.
Okay. Okay.
All right, I wish you well.
Just,
Obviously,
just one more, sorry about this. Just one more thing. Just one more thing.
yes, sir.
Police report. Tracy, police report file, come to the second, back to the second floor, file a motion
To set aside the default judgment.
to set
Aside the default judgment.
okay.
Now, when you do that, you're gonna have to show good reasons why it should be set aside. You have to show, the form is gonna ask you why should it be set aside? And if you can get something showing a police report, showing that you are filing documents because this person defrauded you and what have you, that's the kind of stuff that you want to attach to your motion.
Okay. All right, so this is gonna take some time, a couple days, I mean, whatever it is, because the police report, sometimes it be in a day or two. So I understand.
You know, but this has been going on, at least the case been around 7 years, so you know.
And I've been paying this lady, I've been paying every year, but I'm thinking I'm still kind of young. I'm thinking that I'm paying to build my credit. Man, I'm paying off a debt that my cousin then did. I got her phone number, I got her address. She got so many aliases. Like, I know you got other people that you need to see. I don't want to keep talking like that. Second floor motion, default judgment, and police report. Correct.
Yes, sir. Yes, sir.
Okay. And they just let them have it right now. In the end, like you say, this been going on for many years. Once I can prove, and then definitely I can prove, and they know that it's not me and this lady my cousin been using my name under my social security number, I'm gonna get all my money back. So it's just a little time. Right.
That's what your work project is. I mean, I don't think that you have many options but to try to fight it in that way. And
no, I am.
And I hope it works out for you. I'll take a look at anything that you file. But remember, you need a determination by the police or somebody. You need to establish this person as creating this particular debt, Razor Capital, as creating that debt, and that had nothing to do with you. That's what you need to do.
And just one more thing, and I understand what you're saying. I called the Stinger and the Razor Capital, the attorneys of it. They looked it up, so they did a investigation, but they can't tell me certain things. But it was one particular female, the Caucasian guy. He didn't want to tell me nothing, but the African American lady, she told me so much that I don't even want to go on to that. But she told me, she went deep into it. She said, this lady has been using your name for a long time now. I'm actually looking at this, and I'm not supposed to say this, but I got what you're saying.
Yeah. All right. Well, again, you can file a motion at any time for the court to take a look at those things. All right. So you'll get an order regarding this garnishment, but then I'm looking forward to you filing something, and I'll take a look at it in the future.
Okay, I'll talk to you and see you later, but I'm actually on my way out the door. And I'll see you later. I'm on my way down there.
Yes, sir. All right, Mr. Johnson, Mr. Thomas, I wish you well, sir. All the best to you.
All right, you have a great day. All right, bye.
Bye-bye now. I see another number down there. If you're on the Zoom and you have something in front of you, please say something at this time.
Speak Espanol.
I'm sorry.
Speak Espanol. Spanish.
Oh, this person?
Yeah, this person here, I couldn't understand them, so I told them to stand by, so we see what we can do for him.
Did you get their name?
He couldn't understand me at all. I got his number up there. 7750161. Yeah, I tried to say, hey, hello, hello. He said, no English, no English, Spanish. He kept saying that, repeating himself.
Spaniel? Spanish.
He probably put his phone down.
You know some Spanish, Madam Report?
Hey, Judge, how are you?
Good morning to you. How are you? You know some Spanish, Benicio?
I was thinking, is it what, como está usted?
Let me tell.
Hola, ¿cómo estás?
There you go.
Bien.
That's all I know.
Hola, ¿cómo estás?
Speaking English?
Muy bien.
English?
¿Cómo está usted?
Bien, señor. Bien.
I'm going to pull up Google Translate.
English? English?
I don't think he can hear you, Judge.
Señor.
Speaking English?
No speak Spanish, please.
Yeah, he needed an interpreter, Judge.
1 minute, amigo.
I have to know what case he's on.
Okay.
I'm going to pull up
He
Google
said,
Translate.
1 minute, friend.
They think they do.
Okay, so
We
you
still
hear
don't
me today.
understand them.
I'm not impressed.
They was trying though, they tried. They tried.
He said he don't speak English.
Yeah.
We can't get no, we don't have no case for him. You gotta have an interpreter. We gotta
Yeah.
order that. And then he
Right.
don't-
¿En qué caso estás
right in the
aquí
wrong
hoy?
courtroom.
¿En qué caso estás aquí hoy?
Es el 36033600000.
He's saying a number. Say it
Yeah, he
again?
said his case. He said his case number. Hold on, let me see.
Yeah,
¿En qué case are you here today?
there you go. Say it again, sir.
Yeah.
000. You don't have that.
What case are you here?
Hold on. What case are you here on today?
¿Qué pasteles estás aquí hoy?
Case.
Son tickets. El número es 36033600000.
I think he's saying the Zoom in number.
Yeah, he sent the Zoom number.
And we don't have any Hispanic cases.
What judge were you supposed to see today?
¿A qué juez se suponía que ibas a ver hoy?
No sé, me mandaron los tickets porque vendí un carro y así me mandaron los tickets que no licencia y que no sé qué fue y que no aseguranza. El carro ya no era mío, el carro lo había vendido yo.
Something about his car. Trying to get his car back.
Why can't I shoot your phone? I'm impressed with that act.
He's right. That's
Why are you
right.
talking back to me? Why?
But how come it can't speak that?
I don't really know how to mess with it, bro. I just downloaded it right now.
the interview experience.
I just downloaded it.
Maybe somebody will eventually help you with something. I don't know.
Right, pretty sweet, right? Let's see. What other question can I ask him?
Well, let's do this. Let's give him another date and set up that date. for the interview.
How we gonna give them a date when we don't know?
I'm gonna say it on here. I'm gonna say.
And then, a date and time. And then let's set up for interview. Spanish. See what I'm saying?
Mhm. I don't know, give them March 31st. Like you
Yeah.
get March 31st,
10 o'clock.
10 o'clock.
March 31st.
So tell them we'll have a interview before March 31st. 10 o'clock. Come back.
We'll have an interpreter for you March 31st at 10 o'clock a.m. Come back at that time.
Habrá un intérprete para usted el 31 de marzo a las 10 de la mañana. Vuelva a esa hora.
Just no March 31st.
We'll have an interpreter.
Give them to them.
Habrá un intérprete para usted el 31 de marzo a las 10 de la mañana. Vuelva a esa hora.
No, we don't know the name.
Habrá un intérprete para usted el 31 de marzo a las 10 de la mañana. Vuelva a esa hora.
I'm about to go learn some Spanish or something. That's really good to have. Gee. They got all different types too. It's crazy. Let me see. I'm gonna start a conversation with them. We'll have an interpreter for you March 31st at 10 a.m. Come back at that time.
Tendrá un intérprete para usted el 31 de marzo a las 10 de la mañana. Vuelva a esa hora.
Please, not that word. Please.
Tendrá un intérprete para usted el 31 de marzo a las 10 de la mañana. Vuelva a esa hora.
We're still on the tube.
El 31 de marzo.
Let me try it again so you can hear me.
Habrá un intérprete para usted el 31 de marzo a la... Habrá un intérprete para usted el 31 de marzo a las 10 de la mañana. Vuelva a esa hora.
Okay, that's enough.
Hola, ¿cómo estás?
Bien. Muy bien.
Intérprete para usted el 31 de marzo a las 10 de la mañana. Vuelva a esa hora. Habrá un intérprete. Habrá un intérprete para usted el 31 de marzo a las 10 de la mañana. Vuelva a esa hora.
Amigo.
Sí, amigo.
Amigo. Yeah.
Habrá un intérprete para usted el 31 de marzo a las 10 de la mañana.